Here we are again on Facebook Live. Today we're going to talk about what's the deal with Dower. We've got John Ross from Affiliates Title Group with us, and he is our subject matter expert, and he's going to dive into that a little bit. We got a bunch of questions, but I think Cheech, you asked the most important question just before we started this meeting. What was that question?
What's the number? Let's leave it up to these guys to answer. What's the number one way to avoid dower?
Anybody? Crickets?
Don't get married.
Don't get married. That's the number one answer. Sean Bell wins today. All right, so
Yes.
when you're dealing with dower, from my understanding, and correct me if I'm wrong, John, only 3 states have this currently. It's Ohio, Arkansas, and Kentucky. So that's why I wanted to make
Yes.
it a subject today, is because a lot of our investors are from states that have no clue what dower even is and how
Yeah.
it would apply to them. So is that correct that there's 3 states still, or is there more?
There's 3 states currently, and Ohio actually is either on the ballot or in front of the legislation to get rid of dower in Ohio. It's been a pending deal as long as I can remember, at least the last 3 or 4 years. Ohio, definitely, there's many people that want to extinguish it in Ohio. There's many reasons to do it. There's groups that fight getting rid of it as well, which is probably more divorce attorneys, I would guess.
We're getting some scratching from somebody's mic.
Yeah. So what is dower anyway, John?
Yeah, I was just going to say, explain dower first.
Yeah, so I mean, basically, in a layman's terms, dower is an interest in the property that a spouse has. So, in other words, if you take title as Frank Ruma and you're married, your spouse has a dower interest in that property, even if she's not on the title. So, if you deed to Frank Ruma only and you're married, or you become married, let's say you get married next week, and all the property that you own, your spouse has a dower interest in.
Oh, that's
And
interesting.
I think dower goes back to. Pardon?
I said that's interesting. So I was thinking dower really applied to just if you were married when you acquired the property. It actually applies to if you get married during the process of owning it, is what you're saying.
Sure, because when you go to sell it, you can't sell it without your spouse because of that dower interest. So it attaches. I mean, once you become married, you get a dower interest to all the property that you currently own.
Okay. So
I'm kind of shocked that because of that California and Texas don't have dower, because they seem to protect the spouse more than anybody.
Yeah.
Well,
Seems like it.
when we talk
Absolutely.
about dower, what is the level of interest that the non-signing spouse has? Is it
So,
50%?
I mean, the technical percentage is a third interest, but you don't necessarily sell your property and your spouse gets a check for a third of the sales proceeds. The interest is just there. It's always been a third. The equitable interest can be changed, obviously, or it's negotiable, I think, during a divorce. I think that's where it comes up. But the technical rule is it's a 1/3 interest in the property.
Okay, so if I'm an investor from California and I'm married buying a property in Ohio, does that still apply to me, or is it only for residents in Ohio?
Any property owned in Ohio is subject to the dower interest.
Okay.
So if you're married, even if it's in another state where you own property in Ohio, there's a dower interest.
Okay, so that's
Which means
go ahead.
Which means that person in California can't buy property out here without their spouse signing off at closing.
If they get a mortgage. If they pay cash, they can buy.
Oh, okay. Just if they get a mortgage.
Correct. Can't get a mortgage, the same as you can't sell without your spouse's signature. If you're the only one in title, if you're the only one on the mortgage, that's okay. But you have to have the spouse release dower when they sign the mortgage to be filed in the county records.
So
it's kind of one of those things that your wife doesn't necessarily have to be on the loan, or your husband doesn't have to be on the loan, but they certainly have to sign the mortgage to release the dower if you're married.
okay.
That's interesting, because I was always under the assumption that it was just buying real estate in general.
Yeah.
It's the note that ties them down.
Note ties them down, or if there's other specifics when you go to get a loan. So let's say you're entitled to a loan and you're married, but you need your wife's income to be on the loan as well to get the loan, then the bank could require that the spouse goes into title so that they could also be on the note and the mortgage.
Yeah, and they usually do at that point. Then it's the 50-50.
They're going to want it. Absolutely. It's more equity for them. And in the case of a foreclosure, it's a more equitable interest that they can get back at the foreclosure.
So if the primary purchaser, and we're dealing with Dower, buys a property and they pass away, does the remaining, you said 33% ownership, what happens to the remaining ownership? Does it automatically transfer to the spouse, or how does that work out?
It depends how they're entitled. So are you talking about the spouse that dies is the only one entitled?
Yeah.
So the Dower interest really was designed, I think, partially to protect the interest of a deceased spouse, a widow. Back in the old days, it was the widow. It could be the husband too. But it was designed to protect the only title holder dying and that surviving spouse being left with nothing. Now, there's another particular instance where if you are both entitled and you have a survivorship deed, then the interest automatically passes. The difference is if you're entitled alone, Blaze, and you die, your spouse would then have to go to probate and be included in the probate case to get that interest transferred over into the property. So it's not an automatic thing.
What about if I own the property, if I buy the property through an LLC, does this still apply in that case?
No. That LLC is a completely different entity owner, so to speak, just like you could be an LLC, a sole proprietor, just you to sign. The spouse may not have any rights to that property whatsoever. Now, in a divorce, they may have rights to the LLC assets, but when it comes to the title to the property, they do not. Does that make sense?
It does.
Yeah.
Yeah. That's where it becomes very important when you're obviously buying property and writing a contract and planning ahead of how you're going to take title, especially for investors. If you're buying that property in an LLC, you want to sell it in the LLC. If you take it individually and you do have a spouse, then obviously you've got to worry about that.
So buying the property sounds like the easy part. It's the selling. If the spouse doesn't want to sell, or maybe the spouse just isn't present anymore and you can't find them, what do you do in that case? Because they can't sign off on the property. You got a problem.
Yeah, you got a problem. We've had instances where husband and wife, husband's entitled, wife is not, or vice versa. Could be either way. And going to sell, and the husband signs the listing agreement. They sign the purchase contract to sell, but the wife doesn't want to sell, and then you can't find them, and the deal goes south because the wife or the husband refuses to sign the deed. We never know at the time of title transfer or when we get a contract what the status of the marital household is, right? I mean, everything could be good, everything could be bad. Even though a divorce isn't filed, maybe they're not getting along. And that's really where the dower interest becomes an issue for the person wanting to sell the property, because even though they haven't filed for divorce or even for separation, one spouse can't do anything without the other spouse because of dower.
I've had that happen a few times over the years.
Yeah, for sure.
So let me ask a really complicated question. Let's say I was married when I bought the property and then got divorced and married someone else, but I sell the property after both of these events happened. Now, do each of them have 33% ownership or a third? How does that work?
No, so the dower interest extinguishes upon divorce and death.
Okay.
So if you're in title and you have a wife, if your wife dies, the dower interest extinguishes. If you get divorced, the dower interest extinguishes. Now, in your case where you said you got married again, The new wife has the dower interest.
Ah, okay. Okay, interesting.
Yeah, your divorce decree is going to spell it out, who gets what and what has to do with the property.
Yeah, as far as the equitable interest divide, yes. As far as the signing of the deed or selling the property, yes.
Now, I've got a question. So
Absolutely.
somebody goes to buy the property cash. They're in California. They're married. They come here. They buy a property for cash. So their wife or spouse did not have to sign anything.
So John Doe's entitled?
Yeah, because there was no mortgage, there was no signing of dower. Now John Doe goes to sell that property. We don't know that John Doe is married. Do you find out for sure John Doe is married as the title company?
We have to ask.
And let's say John Doe denies it.
Well, that's an interesting situation, and that could become a potential lawsuit, because if John Doe lies on the seller's affidavit and tries to sell that property even though they're married, that could become an issue. Yeah, I've actually never experienced that.
I'm assuming
for whatever reason, we always find out.
I'm assuming title insurance then would cover down the line if something, if the spouse came back and said, hey, he couldn't have sold that property without me.
Yeah, I mean, obviously, if we've done our job in the due diligence, title insurance, yes, would cover it, but then the title insurance company, the underwriter, would go after the seller, or make us go after the seller for not disclosing it.
I've got another question too. Let's say John Doe buys a property here as a spouse, and even if they live here, they don't have to be out of state, they live here, but one person buys the property, got a mortgage, so there is dower signed off on that mortgage. If that third person goes into foreclosure, does that affect the credit of the spouse? Any idea on that? Or because they signed off dower, they're given their rights away on that mortgage?
I think it probably depends in that case if they're on the note or they're not with the bank. That's not really a title thing, but I'm guessing that the mortgage company or the bank, probably if they're on the note. If they're not, I don't know how.
If they signed their dower away, they wouldn't have been on their note, so then they would be.
I would say no. Could happen though. I mean, credit reporting bureau could pick something up and have it on there wrong or not.
So let's use this as an opportunity to talk about title insurance, because I know it's a little bit off topic of dower, but dower is one of the reasons it sounds like through that conversation that title insurance could be really important. Talk to me about lender title insurance versus owner title insurance and what it does, because real estate agents are often asked that question and they don't always know how to explain that when it comes to closing. Why are these additional closing costs? What do I need this for?
Yeah, a lot of people probably don't know how to explain it properly, but so the difference is the owner's policy protects the owner and insures the owner as the fee simple title holder to that property. The loan policy protects the lender, but the interesting part is it only protects the lender in the case of a default. So anytime you go to get a mortgage, the lender is going to require title insurance to protect them. And that title insurance protects them, their equitable interest in the case of a foreclosure. That's really what it boils down to. If there's a claim on title, it's not going to go against the loan policy unless there's a foreclosure.
Okay.
It's going to go against the owner's policy.
So
that's one distinct difference.
If I own a house and a tree falls on it, or it catches on fire, or a tornado comes through, those are obvious things why I need insurance. Why do I need title insurance?
Well, you don't, the bank does.
Okay.
Yeah, so the bank requires the title insurance. They're not going to give a loan without it. 9 times out of 10, they're selling the loan. So the wholesaler or the big mortgage company buying that note is going to require title insurance. And they want to make sure that their equitable interest is protected. And that's really what the title insurance for the lender boils down to.
Well, I guess what I'm asking is,
you're still going to want the owner's insurance, Blaze, because of that. Back to that dower thing. Something happened 3 years before you bought the house. And now that person comes back and says, hey, that's my property that you're living in.
I think the best explanation for our owner's title insurance and why you need it is probably because if something does happen, you're protected.
So that's
You're
what I'm trying to get at.
against,
That's what I'm trying to get at. Maybe I asked the question wrong. Is give us, if you've been doing this a long time, I'm sure you've run into something with this, but give us an example of some title claims, like a tree falling on a house is obvious with homeowners insurance. What is an obvious title insurance claim that happens in the reason why you need it? The Dower, obviously.
Oh boy. I mean, there's numerous. I mean, we could do a class on title claims. It'd be boring as hell. But let me get an example. Great example is what Frank asked. Spouse in California, right? Unknown spouse, right? Title insurance covers things like that. Unknown interests of parties in title or not in title. I would say the biggest, probably the number one claim you probably see is regarding easements and shared driveways, et cetera, things like that.
Okay.
Encroachments, those are big deals, things not disclosed. Title insurance covers mistakes from the past, not mistakes going forward. So in other words, if you buy, here's a great distinct example. If you buy a piece of property and you get a location survey, which is required, and you own the property and you get a mortgage, and then you go put up a shed, and that shed is put on somebody else's property, title insurance doesn't cover that, right? It covers things that happened in the past. Now, there are some new policies where there are additional coverages for things after you take title, but that's a whole nother topic of discussion.
Okay.
Great example would be a shared driveway that's not filed. Things that could be disclosed by a location survey. So if you buy a piece of property, this is a great one for investors. A little tip: you buy a property with cash, nobody's requiring any kind of survey of any kind. And if you buy that property with cash and you don't get a location survey, and then you find out down the road that a neighbor's driveway is shared with your driveway, as to who has access, who's taking care of the driveway, et cetera. So those things could have been avoided. And the reason we ask people to get location surveys is so that we can show if there is one like that, we can address it before title transfer, or in the instance of encroachments, we can make sure we accept those so that there isn't a claim that we have to pay.
I'm doing that with one of the transactions with you guys right now, cat buyer, and I'm having to do a survey.
Yeah, I mean, it's
like that.
$190 to find out if
Now, I got a question, kind of off topic, but let's say I own a property and I quit claim it over to Blaze, but he never filed that quit claim. Does he have any title on that property until he files it?
No, it has to be recorded.
So if he doesn't record it and I turn around and sell that property.
Yeah, there could be an argument regarding the delivery of the deed, and there's specific laws in Ohio that address delivery of deeds. That would probably end up in some kind of a lawsuit to determine, but I would say 9 times out of 10, it's not gonna go through. A lawyer may argue differently, but that would be one thing you'd have to go to court on. I can't answer specifically in that situation, but to perfect the transaction is recording of the deed. That's what I've always been told.
Okay.
I'm not a lawyer, but
So that makes sense, but I see that happen.
A big takeaway I got right there was if it's a cash deal, the location survey is not required like it is with the lender. So that's a big deal to talk. If you have a buyer that's paying cash, have them do that. That's awesome.
Yeah, okay. It's huge. It's huge. We've been suggesting on every transaction that's cash to get a location survey because, quite frankly, the lender is the one that requires the location survey and the reason they require it is because they want survey coverage from us, the title insurance company. It has nothing to do with the owner. The owner doesn't get survey coverage, but it does protect the new buyer in a cash deal so that they can see what they're getting.
Yeah, that's one thing. A mortgage company is going to protect themselves more than you protect yourself normally. That's why
100%.
I go for everything like that.
100%.
But yeah,
And a lot of that has to do with
it.
A lot of that has to do, Frank, you know this, is as to the selling of the loan and the marketability of the loan itself. Yep.
Oh, so we got a little off track with Dower.
That's okay.
It happens.
Well, here's one thing, just to sum it up on the Dower, just remember, it applies to a married spouse, right? Owning property in Ohio, whether they're married in Ohio or anywhere else, whether they're living in Ohio or they're living somewhere else. The key is the property they own is in Ohio and they have a spouse that they're married to. That's where Dower applies. And another rule of thumb is it extinguishes when you're divorced, it extinguishes when you die. And those are the only two ways to extinguish Dower. Now, there are other proceedings in the Ohio statute that I've read where you can actually extinguish Dower by legal proceeding, but that's a whole nother book.
Does a spouse have the ability to sign off on their Dower if they don't want to be on the property? Or is it automatic?
I believe they can quit claim. I might even have a slide on that, but I believe they can quit claim their Dower interest.
Okay. Well, John, we appreciate your time. I'm going to stop the live, and that was great information.
No problem. Anytime.